If you're a lawyer in India, I'm willing to bet you're overworked. I mean, you're drowning in SLPs that are thousands of pages long. You're sifting through endless precedents, constant drafting. It's completely exhausting. So it's no surprise that you're turning to AI for a helping hand. It feels like a lifesaver, right? But what if I told you that lifesaver is actually an anchor, and it's pulling your entire practice down with it?
Let's just cut straight to it. I want to ask you a direct question. That quick case summary you asked ChatGPT for last week, or that contract you used it to draft, could that single action cost you your license to practice law? You might be shocked to hear that the answer is very likely yes.
Let me be absolutely clear about this. This isn't some problem for the future, something to worry about down the road. The way most lawyers in India are using consumer AI tools right now, today, it isn't just a bad habit, it is actively illegal. So let's break down exactly why that is. You see, every single time you use a public tool like ChatGPT for client work, you are racking up something I call compliance debt. Every prompt, every time you paste in a client's name, a specific fact from a case, or even a strategic thought, you're creating a potential breach. It's like a tiny crack in the foundation of your professional duties. And trust me, those cracks are adding up fast.
I mean, this is the reality for so many of us, isn't it? On the left, you've got this absolute mountain of work that just consumes your days and nights. And on the right, you have this tool that promises to do it all in seconds. It is an incredibly tempting, almost irresistible solution. But this convenience has a massive hidden cost, because the moment you copy and paste sensitive client data into that public chat window, you have crossed a very, very dangerous line.
So how exactly is it illegal? Well, it's not just one single thing. It's what I call a triangulation of risk. Your daily use of consumer AI is probably violating three separate, very powerful legal and ethical frameworks that govern every single advocate in India. Let's go through them one by one. First up, the brand new Digital Personal Data Protection Act of 2023. This law gives you a new title. You are a data fiduciary. Think of yourself as the legal guardian of your client's most sensitive information. Now, when you type their confidential details into ChatGPT, the law calls that processing data. And here's the kicker. You haven't gotten your client's specific, informed consent to send their secrets to a US-based AI company so they can train their models. Without that consent, you are in breach of the act. Simple as that.
Second, we have to talk about the very bedrock of our profession, attorney-client privilege under the Evidence Act. This privilege is sacred, but it is not unbreakable. It can be waived by sharing confidential client communications with what the law considers an active third party. And make no mistake, OpenAI's terms of service make them an active user of your data, not a silent, confidential assistant. You risk destroying that privilege entirely. Just imagine opposing counsel arguing in court that your client's deepest secrets are now discoverable, all because you type them into a chatbot. That is professional negligence on a catastrophic scale.
And third, there's your fundamental duty to the Bar Council of India. The BCI rules demand competence and accuracy from us. We've all heard the stories about AI hallucinations, right? Where the model just confidently invents fake case law. Submitting a brief that contains a perfectly plausible-looking, but completely non-existent Supreme Court citation isn't just embarrassing, it's professional misconduct. It could easily be seen as you intentionally misleading the court.
Okay, so we've covered the legal theory. Now let's get down to brass tacks. Let's talk about the real-world consequences. What happens when this ticking compliance bomb actually goes off? The numbers involved are, frankly, staggering. Now, look at this number. This isn't some theoretical maximum fine for a massive corporation. Under the new DPDP Act, this is the kind of penalty that you, as a data fiduciary, whether you're a solo practitioner or a partner at a big firm, could personally face for a significant data breach. A breach that could be caused by one single, careless copy and paste.
And if you're thinking, well, the AI company will protect me, you need to think again. Remember that I agree button you clicked without a second thought? You signed a contract. You legally gave companies like OpenAI the right to use your client's confidential information to train their future models. You accepted that they have zero legal liability if the AI gives you terrible advice or leaks your data. And you agreed that your data can be kept for 30 days, even after you hit the delete button. You have legally signed away all of your protections.
Okay, I know that was a lot of bad news. Really bad news. But my goal here isn't to scare you away from using technology altogether. It's to guide you towards using the right kind of technology, because there is a compliant, a secure, and an incredibly powerful way forward, and it's called sovereign AI.
This really is the fundamental choice you have to make. On the left, you've got the high-risk world of consumer AI, where your client's data is the product. It's harvested, it's sent to servers around the globe, and it's used for training.
But on the right, you have enterprise AI. It works on a completely different model. Your data is never stored, it's processed right here on Indian servers, and it is contractually guaranteed that it will never be used for training. This isn't just a small technical difference. For your practice, it's an existential one.
So how does this sovereign AI actually build a compliance shield around your practice? Well, it all rests on 3 critical pillars. Pillar 1, data residency, which keeps all client data safely on Indian soil. Pillar 2, zero data retention, which means your prompts and the AI's answers disappear, preserving attorney-client privilege. And Pillar 3, grounding, which completely eliminates those dangerous hallucinations. The crucial thing to understand is that these aren't just fancy features. They are the direct solutions to the 3 legal violations we just talked about.
So what does this actually look like in your day-to-day work? How do you make the shift from using these risky, illegal tools to a workflow that is compliant and completely future-proof? It all comes down to using tools that were specifically built for the Indian legal system. This is the key technology that makes it all possible. It's called Retrieval Augmented Generation, or RAG for short. Now, in simple terms, this means the AI is forbidden from just dipping into its vast, unreliable public memory. Instead, it is grounded only in sources that you provide and trust, like actual Indian legal databases, statutes, and your own internal case files. It starts to think like an Indian lawyer because it can only read Indian law. So just imagine a tool like this. Instead of asking a generic public chatbot, you use a specialized Naya search tool. It plugs directly into verified databases like Indian Kanun, it can read a complex judgment, and instantly tell you the binding ratio decidendi, and crucially, every single answer it gives comes with a citation to a real case that you can click on and verify for yourself. Your research is never stored, and hallucinations become a thing of the past. This is how you use AI to fulfill your duty of competence.
Let's just put it all together. This table is basically the closing argument. Look at every single legal requirement that matters: data usage, retention, location, accuracy, and liability. In every single category, consumer AI fails, creating massive, unacceptable legal risk. And in every single one of those categories, a compliant enterprise solution built for India solves the problem. It makes your practice safer, more efficient, and even insurable against these kinds of risks. The 2 paths forward could not be more clear.
Look, the AI revolution isn't coming. It's already here. It is transforming the legal profession as we speak. So you really just have to ask yourself one simple question. Are you adopting tools that make your practice compliant, efficient, and truly future-proof? Or are you, right now, sitting on a ticking time bomb just waiting for it to go off?